Excellent. Welcome, everyone. Appreciate you joining us tonight. My name is Nicole Cantatori. I'm the head of culture and engagement for Worth Ross Management, and I would like to welcome you all to the February Speaker Series virtual event. For those of you that are joining us for the first time, welcome. These exclusive events are designed to bring industry leading experts to the center stage for a unique and uninterrupted experience like no other. You'll gain valuable insight, learn about best practices, and have the opportunity to ask questions. Our speakers are carefully selected and are familiar with the specific needs, challenges, and opportunities that association boards and managers are faced with. Before we get too far into the discussion, I did want to let you all know that we are recording this session and we'll make it available to all of our board members and our managers along with the other webinars in the series. We want to make sure that all of the board members have the resources they need in order to best lead their communities. And this leads us to today's speaker series event. With me tonight is Clint Brown with RMWBH Attorneys and Counselors at Law. The topic of today's discussion is Collect Knowledge, Practical Collections Advice from RMWBH. So the format for this evening is going to be similar to the previous events, with our panelists presenting the information and approximately 15 minutes at the end for Q&A. So if you do have questions that you'd like to ask the speaker, please make sure that you send those to me via the chat and I'll have the speaker address them at the end. So Clint, welcome. Thank you for being here tonight. I will turn it over to you and I will give you the ability to present.
Thank you, Nicole, and thank you all for having me. Hopefully, I'll do a good job of making collections a little bit more exciting than normal.
All right, you should be able to share your screen now.
Perfect. All right, well, hey, let's go ahead and get started. So tonight's presentation is going to be focusing on kind of collection practices here in the state of Texas for condominiums. As Nicole mentioned, my name is Clint Brown, and I'm actually board certified in Property Owners Association law and residential real estate by the Texas Board of Legal Specialization. Just means I had to take a bunch of tests, and my focus area is primarily in those two areas of the law. All right, so first and foremost, I'm an attorney, got to give that legal disclaimer. So the information that we're going to be chatting about today is based on the law as it exists today, February 23rd, 2023. It's also being presented for educational purposes only and does not constitute legal advice. And look, I get it. There may be some hypotheticals that are going to be asked here tonight. When you send those chats to Nicole, that's okay. Just remember, you get what you pay for. So if it's something you really need a good legal answer on, I strongly encourage you to get with your legal counsel so that he, she, or they can assist in the board making a good decision for your community. All right, so here's our agenda for today. We're going to talk about what is a lien and what is the association's lien for assessments, fees, interest, other amounts due and owing. Is it lienable? And when I say lienable, I mean foreclosable. Then we're going to talk a little bit about unit foreclosure, what it means for you as a community association board, and how often it occurs. How often does a unit foreclosure actually occur and actually make it to the courthouse doorsteps? What happens in the very rare event that an association acquires a unit? And then finally, we'll talk a little bit about the pre-litigation or pre-foreclosure Chapter 82 collection process that both Worth Ross follows and then our law firm follows, and most law firms. So with that, let's go ahead and get going. Okay, so first and foremost, most condominiums here in the state of Texas, and when I say most, I'd say north of 90%, are governed in all aspects by Section 82.113 of the Texas Uniform Condominium Act, 82.113. And TUCA, Texas Uniform Condominium Act, applies to all condominiums, regardless. Well, excuse me, let me back up. This section applies to all condominiums, regardless of whether the condo's declaration was filed before or after a very key date. And that date is January 1st of 1994. I'm going to do a quick sidebar here. Why is that date important? So for those condominiums whose declaration was recorded prior to January 1st of 1994, only certain sections of Chapter 82, TUCA, apply to you. Only certain sections. And the law tells you which sections of TUCA apply. For those condominiums whose declaration was recorded on or after 1/1 of 94, all sections of TUCA apply. So 82.113 is one of those sections that applies to both pre-TUCA and post-TUCA condominiums. Now, there are certain condominiums that have a declaration that conflict with this that are pre-TUCA. In those instances, maybe not all aspects of this section apply. But for our discussions tonight, let's assume it applies in full to everybody on the phone here tonight. So, what is a lien? A lien is something that attaches to a unit within your condominium community. Every residential unit, or if we have some commercial units on the phone, commercial as well, every unit within the association has what's called a continuing lien, and it is a statutory lien. And it basically covers all amounts that get levied against a unit, and it allows for the association to foreclose on those amounts if they are not paid timely. What kind of amounts do we have to deal with? Regular assessments, special assessments, any other sort of dues, fees, charges, interest, late fees, fines, collection costs that Worth Ross may have to incur and levy against the owner, and then attorney's fees if the delinquent account ultimately has to make it over to the attorney. Y'all probably know this, but every community association in Texas is actually a nonprofit corporation. So in a nutshell, the money that comes in is the same money that goes out. You are not a profit-making corporation. And that's where your assessments come in and are so vital to the lifeblood of an association. Because if you do not collect your assessments effectively and efficiently, you're not going to be able to pay the vendors that y'all engage with, your business partners, your management company, your attorney. You're not going to have any funds to keep the association up and running. You're not going to be able to build adequate reserves to maintain the common elements, and in certain instances, limited common elements. So what happens when you don't do that? You run into a term of art, and y'all probably know this, deferred maintenance. So over time, when you're not doing the work that needs to get done in terms of maintenance, it keeps getting worse and worse and worse. So something that may cost $5,000 to fix in year one could cost $50,000 to fix in year 5. That's why deferred maintenance is something you want to avoid. How do you avoid that? You get your regular maintenance done. How do you do that? You hire vendors. What do you hire vendors with? Your assessments, the money that you are collecting from your unit owners. So that is what the lien is. It's pretty much any amount the association is able to levy against an owner for the payment of assessments, and then attorney's fees and collection costs. All right, 82.113B as in boy. And again, this is statutory, and it says the association's lien is higher than every other lien with the exception of, so let's put our lien here, real property taxes are above us. A lien or encumbrance recorded before the declaration is recorded, we don't really have to worry about that one. And then the third one is what's called the first deed of trust, or it's basically, it's called the PMSI, the purchase money security interest. So that's the loan you take out if you have to take out a loan, borrow money to purchase a unit. So Our lien is here. We have the PMSI, that first deed of trust here, and then above that is the tax. So everybody's due money. So we're talking hierarchy here. Tax lien forecloses. It wipes out every other lien below it. It extinguishes the lien from the date of foreclosure backwards. So tax lien forecloses. It wipes out that first lien, that bank loan. It wipes out the association's assessments, and it wipes out everything else attached to the unit, period, end of sentence. It is only from the foreclosure backwards. So if there are assessments that come due after the tax foreclosure, those are still valid. Those still attach to the unit. So it doesn't wipe out our lien in perpetuity. It's just that it's the date of foreclosure backwards. Now, next one, the purchase money lien, that first deed of trust lien. If that forecloses, again, we're below it statutorily, so it wipes us out as well. All the liens below those, though, when we foreclose, we can wipe out other liens below us. So that's how kind of lien priority or lien seniority works. Okay, so the minute a unit owner buys in your community, the first thing they're going to do, they not most of the time, well over most of the time, they use a title company. The title company does a title commitment. They do real property record searches. They pull all the documents that are attached to the unit, and then they give them to the buyer and the seller. They also reach out to Worth Ross, your management company, to obtain what is called a resale certificate. And the resale certificate lists a number of items, but one of the things it does list specifically is how much is due and owing on the unit. How much money does the unit owe up to a date certain? Title company gets that, and they make sure those monies are paid either before closing or at closing. So you show up, you get a settlement statement, and one of those items, if you look through it, is association money that's due and owing. It could be very low, less than $500. It could be thousands and thousands of dollars. Let's say the association levied a $15,000 special assessment against each unit, but they are allowing the unit owners to pay it over a period of time. Maybe you pay $5,000 a year for 3 years. Well, we're in year one, unit decides to sell. That $5,000 a year, it typically accelerates. So on that closing statement, it's not $5,000, it's the full $15,000. So you could have high dollars on that resale certificate. Regardless, closing happens, association gets paid, unit owner comes in. There's still a lien on the property. It's a continuing lien, but the lien is zero. It's the big goose egg. Why? Because they paid everything right at closing. Now, 1 month goes by. Now they've activated the lien. So it went from zero to whatever that monthly assessment is. And then the owner pays it timely, and you go along your way. Hopefully they're set up with ACH or something like that, so they're not having to cut checks every month. Anyways, owner comes in, lien should be at zero. What happens if a resale certificate isn't requested? I call these, most of the time, almost all the time, title is not involved. So what you're dealing with is what's called kind of an arm's length transaction. Well, unit owner number one sells to unit owner number two, right? Buyer or seller to buyer. What happens to the money? The personal liability. So me as a person, I owe the money, but I sell to somebody else. I sell to Nicole. I'm still personally liable for that money, but the property carries the amounts as well. So in rem liability follows the property. So it stays attached. Even though it goes from Clint to Nicole, those monies attach. They stay with the unit. So now, even though Nicole may not be personally liable for the money, the property is still liable. So that means the association, if it has to, can initiate foreclosure proceedings. But again, most of the time, almost all the time, title companies are involved, and they make sure that these monies are paid through that resale certificate process. Now, what kind of right does the association have to foreclose? Well, Section 51.002 of the Texas Property Code gives this power of sale right to the association to conduct foreclosures if it needs to. So we're going to talk a little bit about what a power of sale is, how the trustee relationship works here in a little bit. Okay, moving on down on 82113, let's get into subsection E. So the association has the right to foreclose its lien either judicially or non-judicially pursuant to the power of sale. What is a judicial foreclosure? A judicial foreclosure is what you think, the judiciary, the court system. So to get foreclosure, you actually file the lawsuit. Non-judicial foreclosure is when you appoint your law firm, me as trustee or whoever your counsel is, and then he, she, or they takes it to the courthouse and forecloses. You don't have to get the courts involved for non-judicial foreclosure. Most condos use non-judicial foreclosure. Why? Because it is about a third or a fourth the cost of judicial foreclosure in terms of attorney's fees, right? An attorney has to go through the lawsuit process in order to get a judgment and foreclose. That's going to cost a lot more money than an attorney merely posting the property for foreclosure, becoming trustee, and showing up at the courthouse steps to foreclose. Now, you cannot foreclose on something that consists solely of fines, not allowed. Additionally, the cost of the foreclosure, whether judicial or non-judicial, gets to get added to the unit owner's account. Now, a judgment is a little bit more tricky because you get the judgment, but the attorney still has to do things after you get the judgment. You may not always be able to tack those onto the judgment. Sometimes you can if the judgment's worded right, but a lot of time, or well, sometimes the judge will strike your right to collect the monies after judgment. So that's another risk with judicial foreclosure. You don't get to tack on to the judgment sometimes. Now, non-judicial foreclosure, you get to tack on attorney's fees, interest, collection costs, up to more or less the day before foreclosure. So you're walking there, you're walking to the courthouse steps with all amounts due and owing. So you're starting the sale with all amounts due and owing. A unit owner may not petition a court to set aside a sale solely because the purchase price at the sale was insufficient to fully satisfy the owner's debt. So let's say for some wacky reason, I don't recommend this, but let's say the association's owed $10,000 in assessments, fees, and other amounts due and owing, but for whatever reason, the foreclosure goes through and it only sells for $5,000. So technically, we sell for $5,000. Well, there's still $5,000 due and owing against the owner. We can seek what's called a deficiency judgment for that remaining $5,000, and we go after the owner for that, and we seek a judgment. This says, hey, the owner can't complain about this, even though it was sold for below the debt amount. Now, practically speaking, this never happens for association amounts. Why? Because our amounts are almost always well below the fair market value of the home. So I personally have never had a non-judicial foreclosure that was that sold for less than the amount due and owing the association. But that section's there anyways. Okay, transfer of ownership. The owner of a unit purchased at the foreclosure sale of the association's lien for assessments may redeem the unit not later than the 90th day after the date of the foreclosure sale. So let's walk through this. What does redemption mean? So again, let's assume I'm counsel. We've got a $10,000 debt. I send my required legal notices and we foreclose. And let's say a third party purchases it for $10,000. We'll use easy numbers first. The date of foreclosure, that owner, the old owner, has 90 days to buy back the property. either from the third party or if the association became the owner from the association. Now, here's the rub. Not only does the owner have to pay back the purchase price, and again, 10,000 is what it was purchased for, but they also have to pay back anything that came due after the foreclosure, but when the redemption activated. So any sort of funds the third party may have invested in the unit to make it look good, any assessments that became due and owing between the foreclosure and the date of redemption, interest, late fees, attorney's fees, all that good stuff, the owner has to pay back to either the association, if the association is the owner, or the association for the association stuff, and the third party purchaser for the third party purchaser stuff. So that's the catch, right? They've got 90 days, but they've got to make everybody whole. So the law is designed to make all parties whole, all the money that they've invested in that unit upon purchase. Now, foreclosure happens, association's owed 10, we sell it for 20. Do we get to keep that 10 as profit? That'd be nice. The answer is no, you do not. So we've got a 10K overage, right? Third party bought it for 20. Third party's now the owner. We have to do everything we can to give that money, that 10,000 over to the owner, giving it to the owner, that overage, to the best of our ability. We've got to do our best to try to get those funds over to the old owner. Sometimes it's not too difficult. Other times it's impossible because the owner's fallen off the face of the earth. We still have to try. There's a time period. If we still can't get it, maybe we look for other lien rights, lien holders that may be entitled to the funds. And if we still can't figure it out, we may have to initiate some sort of an action and deposit with the registry of the court. So that is redemption in 5 minutes. All right, 82.113G. The purchaser of a unit at a sale, foreclosing, and association's lien may not transfer ownership during the redemption period, other than to a person who's redeeming it, right? Yeah, that's the only party you can transfer it to. So basically, we foreclose, a third party buys it, they cannot transfer it to anybody other than the old owner. Why? What's the legal significance of that waiting period? Number one, it's fair because there's that 90-day period, and you don't want to have 15 transfers within 90 days. Good luck to the owner trying to figure out who to redeem from. That's problem number one. Problem number two is the person who purchased from foreclosure, they are not a bona fide purchaser. So they're not kind of a good faith purchaser, or what's called a BFP, a bona fide purchaser for value, good faith. Why? Because they know what they're buying. They're buying whatever we're selling, period, end of sentence. But if that owner sells to another owner, that third owner could be a BFP, a bona fide purchaser, which gives them some legal protection. So the law says, hey, we're not going to allow a BFP to buy this thing until the redemption period is over. All right, owner default. So we've got Bob, the owner. Sorry, if there are any Bobs on the call tonight, I'm going to pick on you, Bob. So Bob, owner, defaults in their obligations. Let's say $500 a month. I know that's probably pretty light, but we'll do easy math. $500 a month is the assessment. And so month one comes and goes, they're past due $500. Worth Ross basically says, hey, you owe $500, pay up. Month two comes and goes, still hasn't paid. Now it's $1,000. Hey, Bob, now you owe $1,000. And by the way, you also owe interest, whatever percentage is stated in the declaration. You also owe late fees. If the association has a collection policy that establishes a late fee amount, we're going to levy a late fee of this dollar figure. Oh, and by the way, Worth Ross incurred some collection costs. So now you owe some collection costs. Month two comes and goes. Month three, Now you're up to $1,500 in assessments plus interest, late fees, collection costs. And at this point in time, maybe it's time to turn over the amount to the association's legal counsel. Legal counsel starts taking it, and let's say 2 months come and go, and we're up to $2,500. The association has the right to notify other lien holders of the default and the association's intent to foreclose. So there is the right to notify any lien holder of a recorded lien, notifying them of the default and the association's right. Also, owner is $50,000 past due in assessments and other amounts. And let's say, just easy math, the home is worth 50 and the guy doesn't have another lien on the property. And he says, look, I just want to get rid of this thing. I'm going to deed it over to you. Can the association take a deed in lieu of foreclosure? Yes, it can. There are a few instances where I recommend that, but I've recommended it a few times and we've done a deed in lieu. Most of the time, just proceed through the foreclosure process. Also, it does not prohibit us from filing that judicial foreclosure or seeking what's called a money judgment. And again, anytime before the judicial or non-judicial foreclosure sale, the owner can pay up, right? Pay up or enter into a payment plan. Okay, so let's talk a little bit about the collection process. What happens? We know about what our lien is and what amounts are lienable, pretty much everything under the sun. We know that we cannot foreclose on amounts consisting solely of fines or attorney's fees related to fines. So if the only thing we've got on the account is fines, we cannot foreclose. That's what the law says. So we've got a debt. Let's go back to Bob. He's 3 months in and $1,500 in assessments plus, let's say, $500 in interest, collection costs, and late fees. So Bob's at $2,000. Worth Ross is going to send a final letter, and maybe they send it. They don't have to legally. They could send it directly to the attorney. But let's say they send kind of a final letter. Hey Bob, this is your last chance. Pay the $2,000 and let's be done with it. Again, Bob ignores it, and it gets referred to the association's counsel. I'm going to go through our law firm's collection process. And again, maybe your counsel follows something similar. So we get a file. Clint, please proceed with a demand letter. The first thing our law firm does is we do a title search. We get the latest deed. We want to make sure Bob is still the owner, number one. Number two, we want to make sure Bob is Bob, that everything links up properly. We also pull the county appraisal district records for the unit to make sure the addresses match up so that we're sending the notice to the proper party. We do a bankruptcy search to make sure Bob has not filed bankruptcy, because it is a big no-no to send any demands for payment for somebody who is in active bankruptcy. If you do that, it is what's called a breach or a violation of the automatic stay. When you violate federal law for a bankruptcy, you can get into some pretty hot water and big trouble very quickly. So we do a bankruptcy search as well. We then take a look at the ledger to make sure all amounts due and owing are in fact validly due and owing. Make sure the interest is right. If it's not, we fix it. Make sure there's authority to charge late fees and the late fee amount is correct. All of that good stuff, that's part of our process. And let's assume everything checks out. We input it into the ledger. And then the next step is sending what's called a Regulation F debt validation notice. Think of it as kind of the initial demand letter. And it sends Bob this formal notice that complies with the Federal Debt Collection Practices Act, or Federal Fair Debt Collection Practices Act, also known by the acronym FDCPA. So the FDCPA letter gets sent, it comes and goes, it expires, and then we go back to Nicole. Nicole, I'm going to use you as my go-to, and we say, hey Nicole, we've sent our letter, it's expired, At this point, we can send one more demand letter, or if the board wants to proceed directly to foreclosure, we can do that as well. Our letters are $200 a pop. It includes everything: phone calls, emails, status reports. So there's no ticky-tacky stuff added. And some associations, the debt is so large that they just want to get it to the foreclosure stage. And so Nicole may come back and say, Clint, you know what? They want to go right to foreclosure. We don't want to do another step. Say, okay, we can do that. Or we do a standard process and we send one more letter in hopes that this owner contacts us to either pay in full or enter into a payment plan. Whatever the case may be, we get approval and we proceed with the next step. So again, we run a title report. We review lien and tax searches. We do an appointment of agent for sale. So this is an important one because it's a document that appoints our law firm as trustee for the association. That gives us the right to put on a trustee hat and establish a strong fiduciary duty to walk down to the courthouse steps and sell the property. We are the trustee. We're calling out the sale, and we've got some legal requirements to comply with. But in order for us to do that, the board has to approve us as trustee. That's where appointment of agent for sale comes in. You've got to appoint us as your trustee, as your agent to conduct the sale. So we draft that document, we send it to Nicole. She gets it in front of the board for review and execution and return. Then we send out that notice of sale and that final foreclosure notice. Magic number, 21 days. 21 days prior to the date of sale, we've got to send that notice out. We send it regular mail, certified mail. We deliver it in person. We get a hand delivery. We had a courier to go up there, knock on the door and say, hey, owner, here you go. Please pay. Reach out to this law firm if you need to pay in full or consider a payment plan. So we try to get in touch with that owner as much as we can. It also gets posted with the court down at the courthouse. There's a little area that you post foreclosures. Again, the courier takes care of all of that. And then it's the waiting game. We wait and we hope that the owner is going to contact us and either pay in full or enter into some sort of payment plan that the board approves. So Bob calls our office and says, hey, Clint, I just saw this, man. I haven't gotten any notices, Clint. You haven't sent me anything. Worth Ross hasn't sent me anything. I pull this up and I'm like, well, Bob, I show certified number, 1, 2, 3, 4, 5 got delivered to your house on this date. Well, I don't know how that could be. Is somebody else? Well, Bob, we also sent it regular mail. And Bob, guess what? We also hand delivered it. So we kill Bob's argument that he never got notice. Then Bob says, well, Clint, I need a payment plan. My response is, okay, put the payment plan offer in writing. Once I get it in writing, I send that to Nicole and Nicole provides it to the board. They review it. If they need some advice on whether or not to accept it, we provide that advice and our thoughts. But ultimately, overall, it is a board decision. Now, let's assume that Bob suffered a valid hardship. He's the breadwinner in the family and he had a stroke, cancer, heart, some sort of medical issue. And it's valid. And it's valid on its face, and he needs a little bit more time to pay the monies back. We can do what are called graduated repayment plans, where it starts here and then it increases up over time, with the understanding that Bob is going to have to stay current on his current assessments. If Bob can make it happen, that's great. If he can't, we're back to square one, and we're going to recommend not offering a payment plan the second go round. First go round, let's give them the benefit of the doubt. If they assure us that they can get back on their feet and get caught up, that's great. Bob defaults. We go right back to the process I talked about. And this time when Bob calls, our response is Bob, we've already given you a payment plan. You've defaulted on it. We're not going to give you another payment plan. So we're going to have to foreclose unless you can pay in full. Bob either pays in full or we proceed with foreclosure. Or Bob sells the property. Or he just pays in full. Sometimes, unfortunately, there's the head in the sand thing where, for whatever reason, they've been ignoring our notices. And when they finally figure it out, they pay us in full. It stinks because now they're having to pay attorney's fees of approximately $1,000, $1,200, plus whatever interest, late fees, and collection costs have been levied related to the assessments. So we do all that, but Bob never contacts us. The attorney has to attend the foreclosure sale. So we attend the foreclosure sale. I strike it off as trustee. I put my trustee hat on and I start the foreclosure bidding at the amount due and owing the association. So I'm going to start my bidding at $10,000. And I'm yelling and screaming. There's usually a third party company that I go in and check in with and say, hey, we're going to be striking off this unit. They already know about it because we provided the proper notice at the court. And right when I'm about to get going, I look over at the group and I say, hey, about to get going. And they yell. They say, hey, this unit, this area, this complex about to be struck for sale. And then I say my piece. There's a script that I read from, and then I start the bidding. And it either sells or it doesn't. In this market, it typically sells for a lot more than the association's lien. So in terms of time frame, what kind of time frame are we talking about? Worth Ross, the time frame is up to the board. Now, Worth Ross has been in the business for a long time, so if you need some recommended time frames from Worth Ross, they're going to provide it to you. Maybe it's 2 months, 3 months, 4 months. All the while, Worth Ross is sending demands. Maybe it's 1 month. It may be one of those associations where your delinquency rate is so low that you need to get things paid timely so that you can handle your budget. Or maybe your delinquencies are so egregious that you need for Worth Ross to speed the process up and you need your counsel to be aggressive. Whatever the case may be, there's that process. But once it gets to the law firm, the account gets sent in within 2 to 5 days of the referral being received. We set up the account. We run that bankruptcy search, title search, CAD search, make sure they're still alive, all that good stuff. Make sure Bob is still Bob. Make sure he's still the owner. And then we send the validation notice within 3 to 6 days of the referral being received. There's that little bit of wiggle room there because collections, you've got peaks and valleys. So when it's peaking, i.e. there's a ton of accounts coming in, the time frame is going to be a little bit longer, but when it's a valley, you can get it open quickly and get that validation notice out quickly. 40 days is the legally required validation period. I'm going to take a quick sidebar here. An association can refer it to us and say, Clint, I don't want any letters at all. I want you to proceed directly to foreclosure. That is a legal option for associations where we don't send a validation notice. We literally post it for foreclosure and we send the foreclosure notice to the owner. That is allowable. That is allowed. And I've got some associations that do it that way. But most associations don't want to invest in that attorney fees, you know, the $1,200 to $1,400 right off the bat. They want to try for the cheap option, right? $200. Let's see if we can get it fixed for $200. So it's just a cheaper option. But again, there are certain instances where you want to proceed directly to foreclosure, and most law firms will offer that. Ours does. Okay, so validation notice expires. We let Nicole know, hey, Nicole, it's expired. What do you want us to do? We can send one more demand letter, or do you want us to proceed with foreclosure? And Nicole gets with the board and they let us know. All right, after we get that back, Clint, proceed with foreclosure. We do what's called a nothing further certificate, which is a full title report to look for junior liens. If we see any liens, we provide them notice. If we don't, we can either send that final demand letter or we can proceed directly to foreclosure. Now, again, remember that time frame, the 3-week, the 21-day time frame that we've got to proceed with. Once we post it for foreclosure, again, regular mail, certified mail, and hand delivery. Courier hand delivers it. And then we post it in the courthouse area. There's an area for posting. If we're going through judicial foreclosure, the process is a lot different. I'll talk briefly about judicial foreclosure because we've got a couple minutes. But in a nutshell, Nicole's team does exactly the same thing that they do for non-judicial foreclosure. But once it gets to our office, we send our letters, and then we have to file a lawsuit with the district court. And then we have to serve that lawsuit on the owner. And then once the owner is served, we have to wait 30 days for the owner to file an answer. If the owner does not file an answer, then we have to file a motion for default judgment and wait another 30 days to get the judgment. And we may have to show up at a hearing and again, bill more attorney's fees. And then once we get the judgment, we have to wait 30 days for it to become final. Then we have to abstract the judgment and get it back to the court to issue what's called a writ of execution or an order of sale. Once we get that paper, we've got to give it to the constable and tell the constable to foreclose on the property. So as you can imagine, that's a long process. What happens if you can't serve them? Y'all have seen those movies where the process server's dressing up in all these different costumes, trying to, hide his or her or their identity to get the paper served. There are people out there who know about service and duck service, right? They try to avoid it. So again, judicial foreclosure, that can cause a little bit of a delay. I've had some cases where it takes upwards of a year to serve the person because they keep dodging service or you cannot find them. That's the drawback for judicial foreclosure. Non-judicial, you don't have to worry about all of that. So with that, Nicole, I think we're right on time. Thank you all for listening to me chat for 45 minutes, and looks like we can open it up to the floor for questions.
Excellent. Sounds like there's a lot of moving parts to that. Clint, thanks for being in such a detail regarding it.
Of course.
We do have some questions here. So the first question is, are there any concerns of lawsuits against the board because the HOA is engaging in collection activity?
Right. So good question. And, this day and age, we live in a litigious society. And unfortunately, nonprofit corporations and community associations, we've had the plaintiffs bar in Texas kind of start looking at us a little bit more. So we're seeing an increase in lawsuits. So if an owner thinks they were done wrong, mistreated in some way, shape, or form by the association related to the collection action, they may be able to find an attorney that sues the association. Does that mean the association did anything wrong? Absolutely not. As long as you're with a professional management company like Worth Ross and a law firm that specializes in condo law, basically community association law, then the actual liability for collections is very, very low. Even though it's low, it doesn't mean you still can't get sued. You could have done everything perfect, everything right, but there's still a lawsuit. And that's why the association has insurance. It's called directors and officers insurance. And that steps in to cover the association and the board of directors. You'll also get to enjoy what's called qualified immunity, which surrounds you with a kind of a bubble of protection to prevent your kind of personal assets from getting attacked. So liability is low as long as you're, using the proper professionals to get it done. But yes, a lawsuit can still happen.
Excellent. Thank you, Clint. The next question here is, do you recommend a warning email first prior to the attorney letter?
Warning emails. Okay, so I'm going to do a little bit of sidebar, talk about the law. Chapter 202 of the Texas Property Code says that every decision of the board is presumed reasonable. So board members get this great presumption of reasonableness unless the other side can show the association was acting in an arbitrary, capricious, or discriminatory manner. Why is that important for email notices? If you have the email for every unit in the community, then you can be consistent, right? Somebody's delinquent, manager emails them. If that doesn't work, they send their letters and refer. You're good to go. But what happens if only 30% of the community has their emails with you? What about that other 70%? You can no longer give them an email. So you don't send them an email, it gets referred, they find out you send emails to everybody but them. They're going to allege that you are not consistently enforcing your governing documents. So again, I'm not saying emails are a bad thing, because people sometimes look at emails more often than they do their mail that's in the mailbox. Just be aware of that potential argument that you're not being consistent in enforcing your documents and collecting the monies.
Wonderful. Thank you so much. Next question. Is the mortgage lien, if the mortgage lien is superior to the association's lien, what happens when the association forecloses and this triggers the mortgage holder to foreclose?
Great question. So yeah, so let's get back to that hierarchy, right? So mortgage lien is up here, our lien is down here. So when we foreclose below us, just below us. That's it. Well, the mortgage lien is still attached to the property. So that third party purchaser takes subject to the mortgage lien. So Jim buys at foreclosure, he buys with that lien still attached to the unit. So if Jim wants to avoid getting foreclosed on, he needs to satisfy that lien. He can either pay it in full, or he can work some kind of deal with the mortgage company to allow him to fix it and flip it and then satisfy the lien then. And savvy purchasers, flippers, quote unquote, are going to do their research, and they're going to figure out whether or not there's a first lien on the property. And if so, they're going to do a mock amortization schedule to figure out how much monies are potentially due and owing on that first lien.
Fantastic. And back to the, I think this kind of ties into the previous question you answered. Is there a presumption that the owner will keep his or her email address updated?
Yeah, so I think we can make a presumption or assumption that the duty to update email is on the owner to notify Worth Ross. For single family communities, there's actually a law that says that, but for condos, it doesn't necessarily say that. But yes, I think there's an argument that we could make that presumption or assumption.
Okay, fantastic. And then there was a follow-up question to that, and that all owners have or use email, actually, Clint. That's a good point as well.
Right, and that's the problem is, if you've got 100% of your community with emails, well then, yeah, I think email notification makes sense. But when you've only got 30 or 40% using emails, you've got 60% that don't, and you're not being consistent in your collection practices, which again can get you into trouble.
Absolutely. And then another question, can you simultaneously pursue in judicial and non-judicial foreclosures? If so, when does this make sense?
So simultaneously, I don't know that makes sense, because there's a law out there. It's called an election of remedies. Basically, you've got you've got a remedy, and once you elect to pursue it, you need to pursue it. But there are instances where you could stagger it. So maybe you start with judicial and it's just not working out. You can't get the person served. So you just non-suit it and you go with the non-judicial route because that's easier to effectively proceed with foreclosure. So I could see instances like that. Or, maybe you traditionally go the judicial route, but with this unit owner, they're very litigious and they're going to fight if you file a lawsuit. Maybe you go the non-judicial route there. So there are instances, but doing it at the same time, no, I don't think that, I can't think of an instance where that would make sense.
Okay, thank you. There's no other questions at the moment, but can you forward, I want to make sure that your information is presented. I think that's the next slide.
Oh, yeah.
there, Clint. I want to make sure that everyone has an ability to contact you in your different offices where you all are available.
Absolutely. And if you have questions, feel free to email me. My name's Clint Brown. So my email is C as in Charlie, Brown like the color. And it's just at our law firm's acronym, RMWBH.com.
Wonderful. We still have some time left, so if there's any other questions, I'll give you all just a few seconds to go ahead and type those questions in because they were coming in quickly and then they kind of slowed down. So that's a good sign, I think, Clint. It means that you you anticipated what questions would pop up and you kind of answered them in your presentation. It is a lot of information to kind of digest, but it is very effective and useful information. So it doesn't look like there's any other questions that are coming up at this moment. So I'm going to go ahead and reclaim as host, and hopefully everybody received this information. Wonderful, wonderful. Again, thank you again tonight for presenting, Clint. This was great. And a reminder to everyone on the webinar is that once this video has been uploaded to our YouTube channel, I will send the link out and you can access the webinar. This webinar, along with other webinars in the series. So if there are no other questions, oh, actually, there is another question that popped up. Oh, I guess someone is just thanking you, of course. We appreciate you. So everyone, I will get this sent out. Thank you again for attending. We appreciate your time. And Clint, thank you. I appreciate you taking time to present to our board members as well as our team members.
Of course, Nicole, I always enjoy working with y'all, and I'm glad I was able to present tonight.
Absolutely. And thank you so much, everyone. I hope you have a great evening.